All right, so this is week 3, and I will have a video for you in regards to, but we're going to do a little bit of discussion about our last assignment, the signature assignment, in regards to looking and searching for court cases and finding a theme. So we'll talk a little bit more about that. And I also will post the video in regards to just the follow-up, just in case. And this video will also cover some of the information as well. All right, so this week you have your assignment on the LGBTQAI plus and your thoughts and experiences with that marginalized group and how you'll be working with that group as a school counselor. You guys did a phenomenal job with your first assignment following all the APA formats. So continue to do the same thing. Okay. I'm down to the last 5 people, the last part of the alphabet. So if you are the last 5, that's the only reason why you haven't received a grade, but everything thus far is following all of the APA format. So continue to do what you did with your first assignment. Everybody hit the mark with the subtitles and the subheadings, and so that's excellent because a lot of times I say that and people still don't put it in their subheadings, but you guys did excellent with that. So thank you for listening and following those directions. Um, this week we're talking about negligence and obligation to the court. So I'll go ahead and lecture on that, and then I'll talk a little bit more about our final assignment in the signature assignment and finding those court cases. So and let's see. We'll see if we have enough time for the video. All right, so we're talking about chapters 5 and 6, and I'll do a little bit of information on those chapters. So we're talking about civil versus criminal, and a civil case is a wrong against other persons that cause physical or emotional or monetary damages. And so our cases are mostly the civil cases when we are being sued as part of it. Now, normally when we're being sued as part of it, we have our whole union. Most of us belong to the union. And when we belong to the union, most of that's settled by the attorney. So a lot of times we don't even hear, see, or anything about that. Now, if something does go to trial or continues to go, you'll get deposition. Once you're deposition, then you know that this is a case that's moving forward and that they are keeping you in your testimony as part of it. Now, if you're depositioned, also, it doesn't mean that you're being sued individually. Your human resource would tell you if you're being sued individually and what you need to do to pursue and get representation based on the human resources finding that you had done something inappropriately and therefore you would need to get your own representation. Otherwise, human resources in your union does represent you all the way through, even if the trial is not even if the case isn't settled. You'll discover when you're doing your research on your cases, you'll find that many of these don't get settled for many years after. So if they're not settled for many years after, then the case is still pending. They're still going to court. They're still negotiating, and so on. Go ahead, Amanda.
Sorry, I just wanted to remind you if you pressed record.
Thank you, Amanda. I did. Thank you
Okay.
very much.
Okay.
Thank you so much for that. Oh, somebody's trying to get in. Hold on one second. Mm, okay. All right. So, um, So we're trying. So most of the time, they're trying to seek compensation. So if they're trying to seek compensation, then that's additional monies or monetary damages. A lot of times with our special education, they're not trying to seek compensation, but they're seeking more services. So that's a different one, right? So an individual can be exonerated of any crime, yet be found guilty of breaching the plaintiff's individual rights. All right. So if we committed a crime, which we wouldn't be committing a crime, hopefully, then we might be in breach of the plaintiff's individual rights. In a criminal case, the person is tried by the state and the standard to determine guilty is beyond a reasonable doubt. As a civil trial pits individuals against individuals, the defendants versus the plaintiffs who believe that they were wrong. And that's pretty much what we're doing. We feel that if a person brings a suit against us, they feel that they've been wronged by someone else. So civil cases require only a preponderance of evidence and not beyond a reasonable doubt. So the decision is made based on the information, which is why we get expert testimony from people who do the same job as us. And when we do that expert testimony, then we're hoping that that person says, okay, that the individual acted like they normally should as a school counselor, as this. And so, and then there's a couple of other things that we'll come across that might also make us not guilty. Um, and then we also, the lower standard is allowed because the person is usually suing for monetary damages and not for the defendant to lose his or her freedom. So usually this is just about money. Preponderance of evidence only has to be above 50%. And therefore, that's why in our freedom, Fred Goldman prevailed his lawsuit. As a general legal principle, according to William Prosper in the Handbook of Law and Torts, all four of these elements must be present for civil liability to be proven. Duty, we talked about that. The school counselor owes a duty to the student or the student's parent or guardian. So we are acting as in for the parent or guardian as well. Breach, the school counselor has breached the duty that is owed. Injury, the student or parent or guardian suffers an injury or damages and an assessment is made. Or causal connection. There is sufficient legal causal connection between the breach of duty and the injury. Okay. All right. So with negligence, civil liability for negligence accrues if the school counselor is found to owe a duty to another person. If that breaches that duty, not by not living up to the expectations of the standards. And as a result of that breach of duty causes damages to another person. Can anybody think of an example of that? Go ahead and just shout it out. So you owe a duty. That duty is breached by not living up to the expectations. And as a result, there are damages or costs to another person.
Would it be like child abuse? Not reporting it?
That's one. Anybody else come up with a thought?
In the last class, I can't remember the name of the case, but there was a case where the counselor didn't disclose information to the student about a class and it made him illegible for sports.
Exactly. I was just thinking of that one too. So, when a student is, our duty is to check their high school requirements, correct? And then also, if they're playing a sport and they're going to Division I or Division II, there are requirements, the NCAA eligibility requirements. And for those of you that don't know about that, that's a high school thing. So that's what you would learn in your high school internship hours. And depending on the on the school, you know, if you're at a big public school where they have and they're competing in their NCAA. I mean, I'm sorry, not NCAA, but they're competing in their high school area and they're very good at it in the different sports. You're going to have a lot of students going to D1 and D2 schools. And it's important that they maintain and take the appropriate classes for those D1 and D2 schools. So if a person, a coach offers something to the student, and let's say it's a full free ride, but they're missing 3 classes, but the counselor has checked off that they have taken those courses and that student does not have time to retake those classes before accepting that scholarship, then that's the damages. Okay. The damages is that they're not able to take the scholarship because they don't meet the requirements, right? So we can't say, oh, well, our counseling program didn't talk about that. We can't say our counseling program didn't let us, didn't talk about NCAA requirements and eligibility requirements. Our program in the program itself doesn't give you that information. However, when you're doing your field work and your practicum, it does. And so you are responsible for knowing that information. And being able to, a school counselor owes a duty to a student and a parent, a guardian of the student, or the school counselor breaches that duty that is owed. So we can't say we weren't taught that. We can't say we didn't know that. We're responsible for that information. All right. Now, if there is, let's see, if there is sufficient legal causal connection between the breach of duty and the injury, or if the student or parent guardian suffers an injury or damages and an assessment is made. Obviously, this person who misses getting a D1 scholarship to any sport, they're missing a lot of money. Now, has higher stakes now because of the NIL, right? So back in the day, the NIL didn't exist, and students in college weren't receiving money for playing sports. So you can imagine the amount of money that they would lose at this point. Okay. So we do want to keep that into consideration and why that is super important. Okay, so what is duty? Duty requires the establishment of a relationship whereby the defendant owes the plaintiff a duty to act reasonably. The stronger the duty, the greater the legal responsibility and concurrent legal liability if something goes wrong. So that's where someone mentioned if someone gets harmed, self-harm, right? So you have information that this student has had suicide ideation, right? And so if they have that and you have a safety plan in place for the student, that's your duty. And acting reasonably upon this is always needs to be in place. So let's just say we're having a bad day and we think that now, and I've heard this with my coworkers, that, they're seeking attention. They just are saying that because they want attention. There is at no point that we can determine that information. Okay. So we must act in the same way reasonably. And we'd have to have notation that the student, was doing it for attention. And that's kind of hard to prove. So every time you have to follow your policies for suicide ideation. So if you have a safety plan in place, if the person is having a breakdown, there has to be something that you have to call the parent. If you call the parent and say, well, I don't feel comfortable with the student being here because of the things that they're saying, you have the notation of what they're saying, then you would ask the parent to take the student home. If the parent doesn't want to take the student home, Then you would have them sign that they're refusing to pick up the student, because maybe let's just say the student's been picked up 4 times this week and they've missed out on work because this is happening. Okay, but then the student goes home and causes harm to themselves, and then the parent sues. Okay, you have to have all your documentation in place that you followed every single protocol, because it could have been the first 3 times that they were seeking attention, but now we're at the point where they've attempted to cause harm, and hopefully they weren't successful, and that's important. So I think it was in 2020. I think it was during, 19, before the pandemic, where there was that big case in Chicago where the student came to school with a gun. And the teacher had seen the writings, and this was the second or third time that that the teacher had found implications of wanting to cause harm to other students in their journals and whatnot. So the student was reported, and I got more information after the case started because this wasn't revealed initially. But initially, the teacher did everything they were supposed to, turned in the journals. He was interviewed by the counseling staff at the high school. There was about 4 counselors on duty. Those counselors did everything that they were supposed to do. And then the student went home. So the last time that it happened, they found writings and drawings again. And he came down. They did their risk assessment. And when they were doing their risk assessment, they had come to the conclusion that he was okay. And I'll tell you why afterwards. But he had played the game well. So he said, I'm fine. I just want to go back. I want to take my geometry test, etc. So as the students, they kept him in the office. They were trying to contact the parents. The parents were going through a divorce and did not want to come because they were in their own lives. And so they finally arrived at the school about 3 hours after being contacted, and they refused to take the student home. The student had a gun in his backpack. So after they had followed all their protocol, kept him out of the classrooms for 4 hours, got a hold of the parents, suggested that the parents take him home, but they refused. Then the student left the campus and left the office and went and shot 4 people. So what ended up happening from there was the first incident when he got caught, the mother had said, well, you just have to play the game and not let them know that you're making these drawings and that, these drawings don't mean anything. But the drawings did mean something because it did lead to him. When the parent went home and the shooting occurred, the parents did call. They called each other, found out that the gun was missing, and they knew that their child had been the one that was shooting. So afterwards, this is when, we have had a lot of shootings, and because the school had all of the documentation, the parents were arrested. And they were arrested for not, for having the gun, in a place where he could get it. And then they also were arresting them for not taking him home and taking things seriously. So things have changed and we're moving in a different direction. But in that situation, the school district and the police sought to go after him instead of it being the opposite way, where the school sued the parents are suing the school because they say, oh, they weren't told or they weren't aware. All right, moving on. Breaching. The judgment as to whether or not a breach has occurred with regards to the duty owed is centered on the issue of reasonability and is agreed upon standard of care. Reasonableness includes the precautions that you take. So in this situation in the court case that I described, all the counselors took the most amount of precautions. Even after the risk assessment, they didn't determine, they kept him for 4 hours because they weren't confident that he was at a level in which he needed to go home. His conversation and everything that he was saying did not lead them to wanting. They suggested it because of the past and the history. So, and they wanted the parents there because there is no time at which we do not contact the parent. And we definitely want the parents to come in. We don't want them just by phone, letting them know by phone. Okay. We want the parents to come in, no matter how difficult it is to get them to come in. So reasonableness. This is difficult to define as a person, as it is person specific, and it depends on the individual's background, education, profession, culture, nationality, and experiences. The court system tries to answer the question, what would the reasonably competent school counselor do in a similar situation? And this is where collaboration is super important. Now, if you're at a elementary school or middle school, you're less likely to have collaboration. And that's why you have to seek collaboration because there's no one else there on your campus. For years, this is my 27th year, for years, I was the sole person that was there. But of course, we have a small district. So me contacting, and I know my coworkers well, it would be easy for me to get someone on the phone, speak to them, get their opinion. And I probably don't want to call just one person. Probably want to call about 3. And then maybe even your administrator, and then your administrator gets the director of personnel services on there as well. So that you are all collaborating, and that is where you have the information to make the best decision. The more the team writes and you write out that you contacted this person, this is what the person said, etc., the safer you are. So, educational malpractice. To prove malpractice, there must be a comparison between the acceptable standard of care for a school counseling profession and the specific act or conduct claimed to be malpractice. The testimony of expert witnesses or another counselor or someone well-versed in school counseling often helps to determine whether or not the defendant met the professional standards. Causal connection. There has to be a connection between the school counselor's breach of duty and the injury suffered by the student. Liability in a negligent case hinges on causation. Proximate cause refers to foreseeable of harm or whether the school counselor could have predicted the harm. I think we talked about a court case on week 1 where 2 students got into a fight and there was an injury and they were suing the school counselor for breach of duty and causal connection. And the causal connection was that she could see foreseeable harm between these 2 students based on, I believe one had ADHD and, they were fighting and so on. So this is the reason why she was dismissed from this case and was not found liable was because there was no direct connection to that because they had a past and they had never fought before, but they just didn't like each other, that she could foresee that they would fight and that someone would be injured. Okay. So that's how that works. Injury suffered. Assessment refers to determining the monetary damages needed to compensate for harm an individual suffers, such as an injury, a loss of scholarship, or death. So with death, we see that with the suicides, the loss of scholarship is monetary when they're losing, they're losing money for going to school. And injury, if someone gets injured, like the situation I said. So there's a normal fight, but there's a bad injury from the fight. So nominal damages can be awarded in cases where actual costs cannot be determined. Punitive damages are awarded in cases where the intent is to punish the defendant and deter similar actions in the future. We had a student that is special needs, and the student, was having problems. But unfortunately, the student poked another student in their eye with a pencil. And so we have a large lawsuit case going for that because of the damages. And I guess, the information that the parents received was that the student had, was acting out in this way. And so it was just a matter of time before they caused harm to someone. Okay, obligations to the court. What are the school counselor's obligations to the court? So we'll talk a little bit about the court system. It has has the federal and the state levels, and the court cases involving educators can involve educators at both levels. Although the state court decides most of the cases. So from the highest to the lowest, the state court system includes the courts of the last resort, such as the state Supreme Court, that's the highest, the intermediate appellate's court, the Court of General Jurisdiction, otherwise known as the District Circuit, the Superior or Juvenile, and the Courts of Limited Jurisdiction, otherwise known as Small Claims Court, Probate, or Justice of the Peace. So those are all of our court systems, and many of those you have heard of. And now we'll take a look at the federal court system. And we have the U.S. Court, we have the Supreme Court, and then we have the U.S. Court of Appeals. It's in 12 geographic circuits, 94 courts, including 3 to territorial courts, and the U.S. Tax Court. Then we have the U.S. Court of Appeals for the Federal Circuit, International Trade, Federal Claims, U.S. Courts of Veterans Appeal. And then we have the U.S. Courts of Appeal for Armed Services, the Court of Criminal Appeals, and then the courts martyr. So the yellow ones are the trial courts, and the blue are the appeal courts. So once you don't win there, you can appeal to the higher one. So the highest court, in terms of the body of laws, the Supreme Court of the state, called the Court of Appeals, or the Supreme Judicial Court, and it's in 7 states. The state Supreme Courts are not considered lower courts, even in relation to the U.S. Supreme Court. The state Supreme Court follows the U.S. Supreme Court's ruling on the meaning of the U.S. Constitution, but the highest court in each state is free to interpret the state laws or the state constitution in any way that does not violate the principles of the federal law. Okay? Here are the geographic boundaries and the 9 United States Courts of Appeal in the 9 in the United States districts. And we have one here in California. So court cases begin at the lower or district court level by a plaintiff or a petitioner The plaintiff or petitioner is the one who initiates the court actions by filing a complaint with the appropriate court. The court serves a summons on the person or persons named as the defendants. And then the next step is a plea in which the defendant can respond by a denial, by seeking independent relief, or by introducing an affirmative defense. Okay. And that's kind of like the deposition that I was talking about earlier. So when a school counselor becomes a defendant in a case, it's often a civil case, a wrong against the student or the student's parents. A criminal wrong might involve sexual misconduct with a minor. Some of the most common cases in which school counselors might become a defendant involve defamation and qualified privilege, abortion, birth control, counseling, academic advising, failure to report child abuse, or unauthorized disclosure of information. Again, as I stated, these are the topics that are in our book, and you'll begin to find and search cases on this. Okay, and some of the things that I've written here. All right, so here's a court case. This case involves a 13-year-old girl who became interested in Satanism, and this caused the student to have an obsession with death. The student told several of her friends that she was going to commit suicide. Several of the student's friends reported the suicide threats to the school counselor. The counselor questioned the student about this, and the student denied having any suicidal thoughts. The school counselor did not notify the student's parents about what he heard regarding her plan to commit suicide. The student was later killed as part of a murder-suicide pact with another student. The other student shot the student before killing herself. The student's father sued the County Board of Education for negligence. All right. So who can tell me what was the counselor's mistake?
Not informing the parents or
Not
proper
informing the parents. Mhm. And today, this one happened a long time ago, but actually, this one happened. Now, the question would be following your protocol in California. Now, we can't speak about that for all the states, but in the state of California, it is the law that each district have a policy and procedure on suicide and what the counselor is supposed to do. What is everyone's role in that, in suicide prevention? So at this point, if you don't know what your policy and procedure is for suicide prevention, this would be something, especially if you're staying in the district where you currently are, this would be something that you would want to continue to pursue and make sure that you have that before you begin your practicum or your fieldwork. Okay, so the big thing here is, where was the risk assessment? There's, where was the collaboration with another student? I mean, they had multiple reports, and the parent was not contacted, right? Even now, he did speak with the student denied it, correct? So that it's not that he didn't follow through with what was being told to him, but it's about, okay, I've got all these people saying that this is what the student is going to do. Maybe we need to go through their things. Maybe we need. Now, when I told you about the court case with the gentleman in Chicago, where I am, we had tendency to kind of find a way to go through the student's backpack. And one of the reasons why we do that is because we would have found the gun, unlike the court case in Chicago. A lot of people feel like, oh, that's their personal stuff. We don't want to go through their personal stuff. But however, if you had asked to go through their personal stuff, or asked them like, okay, well, we're just feeling a little uncomfortable. What's in your backpack? Can you share with me what's in your backpack? Now, if they start saying, no, I don't have to share it in the backpack, I would start to get a little bit, okay, all right. You don't have to share, you know, and it's a true statement. They don't have to share. It's their personal possession. You don't have any reason to do a search and a seizure because they're not talking about it. He was totally calm. But maybe if you kind of poked at him a little bit more about that backpack, maybe that would have been a rough spot. But you would have found a gun, which would have led to, being able to stop the incident before the incident occurred. With the girl, it would have been like, can you show me some of your drawings? Oh, I heard you're a great drawer. Can I see your notebook? Can I see some things? Maybe going through that backpack, you would have found something about some writing about her, even though she's telling you she has no thoughts of suicide. So there's clever ways that's why we all take turns kind of as counselors, and we don't try to do this on an island by ourselves. But sometimes people will be able to share more information. Erica?
You kind of hit on what I was going to ask because I know, like at my district, I don't know exactly what the protocol is, just kind of briefly. There's like different colors of, when they're meeting with students that determine what the next step is. And so I was just curious of like when the student is saying no and completely denying the fact that they have suicide thoughts or, attacking somebody or anything like that, like how to get around to get that information yourself.
So you always want to have a team. Okay. So we have our suicide prevention team. That's all of our mental health professionals. And I'm fortunate now to have a BCBA, a social worker on campus with me. I've always been floating by myself, right? So at this point, and then I have my psychologist. So at this point, the team comes together and my administrator serves as the ears. And wherever the child goes individually with each person, the administrator is there taking all the notes. And she's the person that's supposed to connect the dots, help you connect, because you're all individually hearing things. And then you come back together and meet. Meanwhile, somebody else is watching the student. And at that point, that's how you kind of say, okay, we're missing this. Let's talk to them some more. Let's bring them back together and see if we can get more information from the individual. Same with your crisis team. Your crisis team, I'm on the team. I lead the suicide prevention team along with all the other mental health professionals that I have on campus. And I'm the lead. So I'm the one who gets everybody together. I'm the one who makes sure we have enough people. And then I bring in the admin. Now, if my admin isn't there because I only have a principal, I don't have a VP or anything like that, the dean is the next person at hand. Now, if the dean is not there, then I need to find another administrator because it's sensitive information. So I probably have to call another school and say, hey, look, can somebody loan me somebody? And I would call my director of pupil personnel services and I'd say, hey, listen, I need help because I got to put this team together and I need somebody to come over and help me. And because you always need that person who's just listening, right? In the crisis team, I'm sorry, not the crisis team. The crisis team, that's when somebody wants to cause harm to somebody else, right? That team, I'm a member of that team. So it's the dean and the principal's job to get everybody together and make sure they have the whole team together. So I'm the mental health person on that team in case we got the murder suicide pack thing going on, because then I've got to address the suicide aspect of it and bring in a whole nother team. But especially if they're saying that, like, I don't want to live anymore. I don't want her to live without me. Okay, we have a big problem here, right? Because you're trying to hurt somebody else and you're trying to hurt yourself. So we need to go with that process, right? So the threat assessment, which is the crisis team, the threat assessment is different because you're trying to cause harm to somebody else. So there's like 13 points. It's a lot more detailed. And like as the member, I know the information, but I don't have it memorized, right? So I'm just there to listen for the mental health aspect of it and make sure that everything gets addressed, right? But for it's the principal and the dean who are listening for, did you violate something? Okay. Do you have access to this weapon that you're planning to cause harm to someone else with? Right. So that's their job to determine whether, okay, are we suspending this kid, leaving this kid at home until further notice, getting mental health, and they're the ones who have to contact the parent, speak with the parent, and all that. Whereas I'm the person who does all of that with my mental health team, and I let the parent know when the parent comes in that the child was interviewed by multiple mental health people. Like I'll have my social worker, my psychologist, myself, and these are the things that were stated to us. So if they're saying it 3 or 4 times, that seems very repetitive, and it seems like we need to do more, you know, and we need to make sure that they're getting the support and the help that they need. Okay. Any questions? Yes, Gabriel.
Specific to the case study about the murder suicide, I know one parent sued the counselor for negligence, but what about the other students' parents? Are they allowed to sue the counselor for negligence as well, even though they're the one that committed the act of like shooting the student? Or does it fall under a different category?
It would fall under a different category. So you're just really focusing on that's who brought the lawsuit. But remember, anybody can sue anybody for anything. That's why our notes are what's most important. And I think over the years, when I went through my counseling program, notes and your notations were important. But depending on where you worked, and a lot of people got really lackadaisical with their notes and their note taking and where they kept them because a lot of people were afraid of their notes being subpoenaed. So they said they wrote less down. And so the courts are going in the direction of that's not what's going to save you. Having less written down is what's going to get you in more trouble. When you're keeping detailed notes, you're saying, I met with them on this day, I met with them on that day, I met with them on this day. I talked to the parent here, here, and here. One thing that we added, which I don't know why we didn't have in the first place when we first initiated our suicide prevention policy, we never had a paper where the parent signed off that we had this conversation and that this is what the conversation was about. Even though you never met with the parent alone, you met with the parent with the other mental health professionals, the administrator, who all said, these are the things that happened. So obviously, all of us were witnesses to the parent being present and, there. However, they could say, that's not what they met with me about. They said it was a discipline issue because that's what they heard. That's not what they were focusing on. So we developed a paper that says that we met with you on this day, put the student's name in there. We did a risk assessment, and as a response to the risk assessment, we are requesting that the student go home, whatever. And then the second part of that page is resources, and that we're providing you with resources in the event that the student is showing additional signs. We encourage you to call 911, and we have that, and that we've given you the resources. So the signature is that we had this whole conversation. We give a copy to the parent, then we keep the original, and then we also give them resources because they can see you and saying, well, you told me, but I didn't know. I left them. I had to go back to work. How many times has that happened? A parent had to go back to work, left the child alone. The number one thing, well, in California, is choking themselves, hanging themselves. So that's the number one in California, and the next is guns. So a lot of times they hang themselves in the closet, do these type of things, and they find ways to cause harm to themselves. And so you want to make sure they don't have access to that. They'll say, Well, I had to get back to work. I just told them to go lay down and rest. And so no one was there. So we always, it says that we tell them that they need to be supervised, they should not be alone, and that whoever is supervising them should know. Because a lot of times you leave the grandmother in charge and you don't tell the grandmother anything. Why don't we tell the grandmother anything? Because the grandmother can't handle it, right? Makes sense, but it doesn't when you left the kid in a fragile state, right? So these are the things that we have put in place and what social workers helped us to see. Because when we started hiring our social workers to come and work in our district, they were like, you're missing this, you're missing that. And, we're a small district. So and most of us have gone through our counseling program many years ago, right? And so when the policy came into play and it was legalized, then our district just followed and made sure that they had anything. But the person who's in charge of us usually doesn't have mental health background. Now, of course, the policy goes through the lawyers, it goes through all of these things, but you learn from experience. You learn that, yeah, I've had a million conversations, but did I give them any documentation? Did they sign anything? Are they in agreement? And the agreement isn't whether you agree with what we're saying, is that we had this conversation. That's what the agreement. And that's how I pose things. Always get your lines together. Like today, we had a really upset parent. I said, we will investigate. She was screaming and hollering. It was a racial thing. She kept saying something. Someone said something racial to her kid. I said, we'll investigate and we'll get back to you. Then she moved to discipline. I said, I'm sorry. You just gave me some information. I need to investigate and we'll get back to you. And she wasn't. So you have to have your lines that, are not demeaning to the parent, but also that give you that opportunity, because they'll say you said this, they'll say you said that. But all I said was, we'll investigate and we'll get back to you. You're dismissing me. I said, no, I don't have any more information, because you're accusing our employee of being racist. And I have no information for you. And I didn't tell her that the employee wasn't there today. I just simply said, we'll investigate and get back to you. When you're speaking with them about suicide, it's like, we did a risk assessment. However, we feel that it's in the child's best interest to go home and with supervised by a parent or guardian. And that's our, thing. And if they say they can't and they won't, well, maybe it's not best for them to go back to class. You supervise them until their parent comes and picks them up. Christina?
Yeah, I was just curious. Let's say I just was wondering if it's appropriate to approach these meetings with parents like a lawyer would. When the meeting is done, you talk to the parent, just jot down like a sentence that says, I was informed of blah 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 blah, and have them like sign it at the spot. Would that be something appropriate for having notes and like later on if it comes up that they're distorting a story that
Well, see, and that's why you have a team. So what helps us is the team. Never meet with a parent alone. Especially after an incident such as this one. Like if we're talking about threat assessments or crisis situations, you want to have other people present. Having the administrator is the most important, because the administrator is going to say, okay, they followed this protocol, that protocol, and this. And they're supposed to be aware of the protocol. Now, sometimes you have a brand new administrator who knows nothing. So they're relying on you. So what you need to do is make sure you have everything in place. And, like I said, sometimes you have to continue to make those type of suggestions. When the social workers came in, they badgered our new director of people personnel saying, they don't have this, they don't have that, they don't have this. I had been saying it for a year, like, how do you show that you had this meeting? How do you know? Because the parents were walking out. Well, something must have happened that made them start to think about, yeah, we don't have that form. And they created it. And like I said, everything goes to the lawyers. But once it goes to the lawyers and it's approved by the lawyers. But to your point, Christina, just jotting something down, most people won't sign anything. I mean, in my area, most people won't sign anything. I can't even get them to sign their school attendance review contract. They'll say, I'm not signing that. They know their children haven't been in school for 30 days, but they say, I'm not signing that because that means they know that once they sign that, they're admitting that those are not that they haven't been in school. So, and okay, my line for that is I write refuse to sign and move on. And then I have my secretary or someone else sign the paper as well. And usually they're present because the attendance clerk is present. The attendance clerk heard them say, I'm not signing that. So I say, okay, that's fine. And you don't waste any more time. And they're so like, like she's not going to try to, nope, I'm not. Have a great day because it's still going in the queue. Bye. And you don't even have to say those things. It's just, that's what's going to happen, And once you write refusal to sign, I've had people, say, oh, I'm not coming up to sign that. Then I say, spoke to parent by phone, informed parent by phone, signature, and then moving on. And that's it. And then you document in the system, like we have PowerSchool. So we have, okay, that I made a phone call, a document. I reached the parent. I told the parent said that they're not coming in to sign that paper, especially if they're not the pickup person. If they're not the pickup person, that's usually when they'll say that. But if they come up there at some point, they know me. I'll run out to their car. I know their car. I know all the other people. I'll run out and make sure that I say, hey, can you sign this now? Because we talked about it by phone. And most of the time, they'll sign it right away. Okay. But my point was a lot of times we got away from keeping notes for subpoenas and things like that. I want you to go back to taking copious notes. Now, when I say copious notes, there's no formal. Most of the people tell you that the legal, we just went through training on create with the crisis team. And like I said, I'm just a team member the threat assessment team. I'm just a team member. And people wanted like, oh, we want this document. And the lawyers said, because we were trained by lawyers, they said, and they're telling you what's being sued and what's winning and what's not. So the people who were who were losing the lawsuits were the ones who kept no notes whatsoever. They had no timeline. They couldn't answer the questions. So the system was like, well, you didn't inform. You didn't do this. You didn't do that. When you have documentation, they also said the people who wrote out all these forms and you wrote out a procedure. And guess what? They didn't follow the procedure. You're going to get sued because you wrote this and you said, so, and here's how the question goes. So everybody gets trained on this. Yes. How many times? Once a year. And everybody who needs to know this information has access to these papers. Yes. It's found on our district website. So if you are an employee and you have this situation, you can find this documentation on the website. Okay, you lost because the person didn't fill out the paper. Right? And but there's no law that says you have to have a paper, unlike the suicide prevention policy. So with that, now you've created a system and people aren't following it. You're going to lose every single time. So, and you can see how that can fall to the wayside, right? Because you're training them, but then if you're not using it and, people are doing different things, you can see how that can cause a problem until someone causes harm to someone else, right? So the law states that all you have to do is have notes about the threat assessment, that you spoke to the child, that you did this, that you contacted the parents, and all the dates and times of when that occurred. They don't need it on a fancy piece of paper. They don't need it with signatures and all that. They just need you to know that you did step 1, 2, 3, 4, 5, and that. The more you write out the policy and procedures, the minute someone skips a step, that's when the lawsuits happen. And remember, we're not privy to most of these lawsuits. Let's be honest. We hear about a lawsuit because if you work about it, you say, you know so and so? Yeah, they did this. That's how you hear about it. But you never hear about what happened, the details, unless you know someone who was depositioned, right? And they tell you only their portion, like the questions that were asked of them. But you don't have the whole case and all the information until it goes to trial, right? So just keep in mind that, all of our districts have lawsuits, many of them pending, and we don't know the details. We know the incident, but we don't know what they were suing for, who got sued, and are they suing just the district or are they suing individual people as well? Okay, and who's named in the lawsuit? All of that we usually don't have. All right. Okay. So I want to show you. Mhm. All right, let me share my screen really fast. Okay, so I'm looking, let's say, okay, so we're starting how we would begin searching for our 3 cases. Okay. Now the cases should be under the same, umbrella: negligence, duty to breach of duty, things like that, right? And as you're going through the book, you're finding something that you're interested in. So I just kind of Googled, I wanted to show you what I Googled first. Can you see that? Everybody can see that, right? So I Googled recent court cases on negligence with school counselors. Now the William Hart came up. Let me see what this one is. I didn't pay attention to this one, but oh yeah, this is the one. Okay, so this is the one, and this one is complete. This was going to kick me out because I didn't. Okay, let's see. Okay, didn't. Perfect. Okay, so with this the William Hart, it's in California, and it was a minor, and this is the whole case because it happened, I believe, in 1991. So obviously, it's settled at this point. So here is where I would get all of my information. This is the actual court case, and it's because this one is old. Now, many of them you won't find that, so I'll give you a second thing. But this one was just one. The school guidance counselor this one was sexual harassment. Okay, so this one and negligence. So had a known history of child molestation, and the school district can be liable for negligence for hiring that student. So that's where the teacher. So that's where the negligence came in. All right. This is 66 pages. So because this has been settled, so it's very detailed, right? So this is what I mean about trying to search for your thing. Now you've got to read 66 pages and highlight the most important parts as it relates to the assignment. So as we talked about, the analysis and the synthesis of it is I don't want the whole court case. We're talking about the negligence aspect of it. So you're synthesizing that and talking about in our literature review, what does everyone say about negligence? I just gave you all of the history on negligence, how it can be used for a school counselor. That's all the stuff that you're talking about when you're synthesizing, right? And you're going to reference this specific court case. Like in this court case, negligence occurred due to the hiring process of the school district. That's my sentence, right? Because I am not specifically talking about the case at this point, right? Now, when I get down to the section where I'm talking about the findings of the case, right? And I might give a little bit of a background, right? So the district was sued because they hired someone who had a history of sexual molestation. So that's my background, right? Now, obviously, did more things to the students while he was there. How many or he or she, how many or what they did is in the 66 pages. But as you can see, as I'm doing my synthesis part, these are the important things that I'm talking about, right? Now, once I get to the findings section, I'm going to take my 3 court cases and I'm going to tell you the results. What happened? So in this lawsuit, and I did not read this, but in this lawsuit, they're going to tell me what the findings are in these 66 pages. Let me close it a little bit more. So, and it, it kind of goes under all this, and it's going to give you other court cases. And this is where you can find other court cases that kind of reference. It's not going to be the same on negligence, but they reference it because that's how they get their decisions made. Okay, so there's something on the list. Let me see if I can go down to, because it's 66 pages. Let's see. Okay, let's see. Okay, so now it's telling me I'm on page 35, but it's giving me some things that, that the school district didn't do and what they're being claimed. And this went, I think, to a higher court. So it started in the low court, then went to a higher court, which is why it's 66 pages and it's actually completed. So this is just one of the ones that's kind of really very long. And I'll show you another one where it's a little simpler, but it'll have it in the findings section. It'll say there's a deposition of all the people that were involved in the hiring process. And this one actually has all of the court testimony and stuff like that too. So, right, the testimonies and everything. Let me go down here to the findings. So here it is, kind of like the guidance counselor plays a crucial role in developing high school students. So obviously they went on and he was sexually harassing another high school student with that background. So that's where all of that comes from. So the findings, I think this person was found guilty. So basically, but it's not just the person, it's also the school district for not doing their due diligence with the situation. So then in your findings, you would tell us why the lawsuit prevailed and why the people were considered guilty and so on and so forth, right? On this one, I just Googled another one that And so like, let's just say another one was referenced and you said, oh, let me see why they referenced this one. So all I have is the actual case. Then I want to go to the just the dockets and filings or either case law. One of the two that will give me the lawsuit itself, right? And I want to make sure I'm on the right one because there's a lot of them here, but I want to make sure I got the one that I inputted. So here's the case text one. Oh no. They took it off of case text. Probably because it's completed. But then I would want to get the so these are all the filings. This one happened in 2018 to 2000 and with case law, it just got removed from it, but with case law, it's free, so you guys should not be paying for these documents, okay? Yeah, all of these that I'm clicking on right now are not the ones I want, so do not do those. My case text is what I always use, and so no. Okay, so I've got to find another one for you, but in I'll have better examples for you because usually case text is what I'm using, but that's what you would find. That's what you would do in the process you would take into looking for your three court cases, right? And then you're following the guidelines of the written assignment and putting all of that information in there. When you're doing your literature review, your literature review is encompassing what everyone is saying about that topic, negligence, breach of duty, etc. Okay, because you're not going to be able to find it on the specific court case itself. Does everybody understand that? Okay, so you're saying, this is what they say about breach of duty. This is what they say. This is what all the authors say about that. Remember, you're not doing a full literature review. You are doing a small literature review, which will only take up about a paragraph, no more than a page of your documentation. Okay. And why you're doing what you're doing. And you're incorporating the court cases into that literature review. Okay. Now, this was just my sample. I'm going to do a video of just because we talked about the cases and the laws and all of that. And I wanted to just kind of show you how you begin looking for something on negligence, a topic. And then I would keep looking for other court cases on negligence and look in different court cases and text court case text for other examples. And then also I will provide you with a list of cases that you can use to get started that are not in our book because you cannot use any of the cases that are in our book. All right. Any questions so far? Again, I will have a video that will go over in more detail, just exactly showing you how to start searching and go through the steps of the final assignment. And I'll have that up by tomorrow.
I have a question. How many cases should we be looking at?
3. You're only looking at 3. The assignment says 3.
And it's like 3 of the same, like 3 on negligence,
Kind of
or
want
can
them in
be
the
one?
same, right? But it doesn't have to be the same level. So if you have negligence in elementary, you have negligence at the university level, those all count.
Okay.
Okay.
And can they be different, like a civil or not
Absolutely.
civil?
Yeah, none of that matters. The
Okay.
overall our common theme is negligence.
Okay.
Gabriel?
I'm not sure if you covered this, but do the cases have to be already settled or can it be ongoing?
No, you can actually say in the findings, this is still in progress.
Okay, cool. Thank you.
I have a question. There's so many cases in our books, and I know we're still going through, so how do we know that they're not in the book?
You just want to reference it, go back into the back of the book and look at it and look at the index and make sure it's not there. And like I said, I typed in California versus William Hart, but so many other things came up. So you want to make sure that you've got the right one. Because William Hart was sued the William Hart Union's High School District was sued so many times. There's a lot of things there. So you want to make sure that you have the ones that you want. All right. Yes, Christina.
So I'm just kind of worried about choosing a topic that might be maybe too broad or too generalized. Like how specific do we, let's say I pick FERPA, is that too specific? Would it fall under the umbrella category of, say,
So in our book, she lists the ones that are the most popular for school counselors. Kind of stick with those, but not to say that you can't use something else. But you might not be able to find that many court cases where people have violated FERPA, so FERPA, that's not the HIPAA, yeah, but FERPA, not so much. I mean, because it's about finding people who did that, so it's more about breach of duty, standard of care, child abuse, not reporting it, right? That's a law. Sexual harassment, molestation, all of those things. Those are, for us, it's about not reporting those things. Suicide, not reporting it, which kind of falls under our standard of care and breach of duty. We have a duty to report all of the things I just mentioned. Okay. And so basically you're looking for tying things together, right? So if we do standard of care, right, and we have standard of care, a counselor was being sued, like the one I talked about earlier, where this foreseeable harm, right? Then I have standard of care where they didn't report something to someone else, which is maybe about suicide or something like that. Then I have standard of care where a threat assessment, okay, and something happened. Those are all standard of care, but what happened to the student was all different. Or I can throw in standard of care, loss of scholarship.
And that's actually goes back to so standard of care, it seems like a lot of the court cases would fall under standard of care, and so would that be okay?
Yeah, that's fine. Yeah, so basically you're saying that we have a right to provide this type of standard of care, and these are the court cases. They don't all fall under that, specific, but we've got damages were lost, we've got monetary, we've got life, we've got this, and the standard of care wasn't provided. And then we have injury. Now, in those court cases, those three, one, there was an injury, but no death. One, there's a death. And then another one, a loss of wages. So you see what I'm saying? You could put all three of those together and you're talking about standard of care and our responsibility. Does everybody understand that? But the cases themselves are all different, not focusing on one thing. Child abuse, not focusing on one thing. You know what I mean? Breach of duty follows the same way. We don't have the Privacy Act as much. Other states have the privacy, which means a student reports something to you and you go out and share it with someone else. Because when the student comes in, there's rules for privacy. Now we have confidentiality, right? So then that's breach of confidentiality for us. And so but have we been sued a breach of confidentiality? I don't think that's a top one, but you might be able to find something in regards to that, where a student, because our confidentiality kind of stops at 12, because they're kind of like adults at 12 for us, unfortunately, but they are.
And it
Yeah.
has to be school counselors, right? Like not teachers. I'm just thinking because it was in the news recently about that
No, it
Mary
doesn't
Kate
have to
Letourneau.
be. No, it just needs to be related to the school. And then, like, you're tying in what should the person have done. So maybe the teacher got sued because they didn't send them to the counselor.
Okay.
Yeah.
I was just thinking of the Mary Kate Letourneau case because there's some sort of anniversary of it right now. So it was on the news. But obviously she was a teacher, not a school counselor.
Mary, she was the one who slept with the student.
Yeah, and then married him and had a family.
Oh, yeah. If you can find information on that, yeah.
Okay.
Breach of duty. Yep. She violated. And then you can, so I hope now that you can leave this evening with more information on looking for your court cases, because you want to start looking for them, because like that William Hart, that's a lot, 66 pages, but it's settled. So there was a lot going on in that case, right? And I gave you the highlights, just the part about the person having a history and then going into this, being hired and then going into a school district, which became his predator. He became, I'm saying the wrong word. Okay, he was the predator. So having people to be able to victimize, the word. Okay. All right. So upcoming assignment, LGBTQ, AI plus, and your views on that. You have 3 videos to watch about that. You do have to reference the videos in your assignment, so don't forget to do that like you did with the professionalism. You referenced Dr. Stone. Again, some of the videos are getting old, so if it doesn't apply or you see that things have changed, mention that. Mention that in your report, or if the views have changed, or if you see it different from, like, you can see the point of view from, I think some of the videos take place in the Bible belt, and we are not in the Bible belt at all. So maybe we have a different perspective here in California. Mention that. Those are ways to, kind of talk about your experiences and how you will apply those things, or maybe how it's not a major concern for you growing up here in California if you did that, so, or maybe it is a big concern for you growing up here in California. Who knows? So make sure to put those things in your document, in your report as well. Okay. There's no right or wrong. You're giving your opinions, you're answering the questions. And so you just want to cite your information as well.
I have another quick question about when
Sure.
videos listed on the rubric, it's called Crossover Kids, but when you go to YouTube, has a different title. So I just wanted to make sure that when I reference it, I'm referencing it correctly. so I wasn't sure where to put crossover kids. I think the YouTube title is How Young is Too Young.
Yeah, just
For
use crossover kids because sometimes when the YouTube might be up and published by someone else and they just kind of have it in under a title that gets more hits per se, not so
okay.
much where it came from because it's all about hits. It's all about how many people come to your and watch your YouTube.
Okay, so you want us to use crossover kids as the title for that video.
hmm hmm
Okay, thank you.
All right. Any other questions so far about our set? Remember, is it week 5 that we do our presentations? Yes, week 5 is our presentations. So, what during week 5, you have your PowerPoint presentation on that group. So if you're not going to be present, you need to contact me so we can make arrangements on how you'll do your presentation for me, because it's for me, not for, and then the classes listening to you if you have a scheduling conflict. And I'm totally fine with the scheduling conflict, because I know that graduations are approaching and happening, and people have things, at all levels. So I understand, but we just need to have an understanding as to how you're going to present it to me. All right. All right. So that's it, everyone. Thank you so much. You have a wonderful evening. Yes, Samantha, does anybody have any more questions? No,
Yeah,
is that a
sorry.
hand, Samantha, or a wave goodbye?
No, it's a hand.
Okay, yes.
I had a question in reference to the assignment that's due this week. In the rubric, it says to describe 1 or 2 themes from the readings or videos in narrative. So is that just kind of for us to maybe pick
Yeah,
like,
that's what I'm talking about. That section when you do your subheading, that's where you put that in.
but
The
like,
themes. Yeah, so your heading is themes from the video, something to that nature, and then that little section is where you're referencing the videos.
okay, so we just identified 2 different themes and then we discuss them. Okay, thank you.
Any other questions or concerns? All right, you guys have a wonderful evening. Good night.
Thank you. Good night.
Good night. Thank you. Good night.